Good afternoon. I'm Peter Bartinik, a civil trial attorney practicing law here in Connecticut. Today we're going to talk about employment law and medical leave. Particularly, we'll talk about the Family Medical Leave Act. Many people call me and they believe they've got certain rights to take time off from work. For example, people think that if they have a doctor's note, they can take time off from work, or if they have a serious illness, they can take time off from work. And lastly, many people think that if their injury was caused on the job, that they just have a right to take time off from work. And the fact is, it's not true. And what happens is people might take unauthorized leave, or they may get into an argument with their boss about it, and they can end up being fired. So I hope this video helps someone save their job by not taking unauthorized leave. It helps to know your rights when it comes to medical leave. Let's talk about the Family Medical Leave Act for a minute. First of all, what I want to do today is put forth about 3 or 4 important points involving the Family Medical Leave Act. It's a complicated statute. We're not going to go through everything. Just 3 or 4 takeaways so that you can know the basics of the Family Medical Leave Act. First of all, there's a state version and a federal version. The Federal Family Medical Leave Act applies to employers with 50 or more employees, and the state of Connecticut Family Medical Leave Act applies to employers with 75 or more employees. So the general rule is, think of it this way: if it's a large employer, or the Family Medical Leave Act will probably apply to the situation. The amount of leave that a person can take under the Family Medical Leave Act varies. It's 12 weeks of leave under the Federal Family Medical Leave Act and 16 weeks under the State Family Medical Leave Act. The leave under the federal or state Family Medical Leave Act is unpaid leave. You don't get paid leave. And lastly, there are many definitions that apply. This is a statute. So as with all statutes, you have to meet all the definitions in the statute. There's a definition for an employer and employee. For an employee, you have to have a certain amount of hours. There's a definition for a serious medical condition. You could have a very serious medical condition, but if you don't meet the requirements in the definition of serious medical condition under the Family Medical Leave Act, then it doesn't apply. There's requirements for giving notice to the employer, and there's rules that apply. What's important to know is the Family Medical Leave Act applies to some situations and not all. It generally applies if you're dealing with a large employer and you're a long-term employee. It's something that, if you think it's relevant, you should look into it and confirm it by checking the definitions. So that's your tip for the day, and I hope this helps. Have a good afternoon. Bye-bye.